today marked the first day of President Biden's new commission to review the Supreme Court and its structure and its processes. You know that they'll be exploring the length of service, possibly term limits or the pros and cons of term limits, the size of the court, questions of the shadow docket and docket rules. We have actually on today's panel, we have one of the members who will not be speaking about that at all. So we'll stay clear of that with Justin Driver, but we will be talking about other things. But fortunately, he was able to join us this evening as well. We've got an extraordinary panel. Of course, I just mentioned Justin Driver. I'll introduce everyone in a moment. Eric Holder, of course, Janai Nelson from the Legal Defense Fund, and Adam Liptak from the New York Times. So it is a momentous time. The Supreme Court just granted cert in an abortion case down from Mississippi that could possibly change the landscape in that area. They also just granted cert in a gun control case out of New York, which could also be very important. As you know, Jones versus Mississippi just came down. The court reversed tack on its sentencing for juvenile persons who offended when they were young, allowing life imprisonment without parole sentences. We also have just this week, the United States Supreme Court denying a retroactive effect to the Ramos ruling on non-unanimous jury verdicts down in Louisiana. And actually in the process modifying the Teague versus Lane rule to get rid of the possible exceptions, the watershed exception, meaning that all rules will no longer apply at all, no possibility that they would apply post-direct appeal. We've also got a new shadow docket we need to talk about today. We've got a reduction in the number of merits opinions. We're down in the 50s now. So it's a remarkable time for the Supreme Court. With, of course, a changing of the guard at the White House. And these are some of the most important issues for us to address. So Eric Holder and I thought it would be great to turn our focus on the Supreme Court tonight. And we have an extraordinary all-star panel to do that tonight. Of course, Eric Holder joins me. I think I've introduced you, Eric, maybe 25 times by now. And and of course, the only person who needs introduction on this panel is probably me. But so I'll keep it short. Everybody knows Eric Holder, welcome back, welcome home. Eric Holder was the 82nd Attorney General of the United States, and most importantly, graduate of Columbia College, class of 73, and of Columbia Law School, class of 76. So it's wonderful to have you back, General Holder. We're going to skip the formalities on this panel tonight. So it's wonderful to have you back, Eric. Thanks. We also are blessed to have Janai Nelson with us this evening, who is Associate Director-Counsel at the NAACP Legal Defense and Educational Fund. Janai determines and executes LDF strategic vision and oversees the operations of its programs. And of course, is also a member of LDF's litigation and policy teams. Janai was one of the lead counsel in VC versus Abbott 2018 at the United States Supreme Court, a federal challenge to Texas voter ID law. And prior to joining LDF in June of 2014, Janai was Associate Dean for Faculty Scholarship and Associate Director of the Ronald Brown Center for Civil Rights and Economic Development at St. John's University School of Law, where she was a full professor there, of course. So thanks for joining us, Janai. We are also joined by Professor Justin Driver, another dear friend and colleague who is the Robert R. Slaughter Professor of Law at Yale Law School and an eminent constitutional law scholar. He's the author of The Schoolhouse Gate, Public Education, the Supreme Court, and the Battle for the American Mind. That's an amazing book. Everyone should read it. It was selected as a Washington Post Notable Book of the Year and Editor's Choice for the New York Times Book Review, and it's received a lot of distinguished awards. And as I just mentioned, Justin is on the Biden Review Committee for the United States Supreme Court Review and Analysis. And of course, we are joined again by Adam Liptak, who is the preeminent Supreme Court expert, reporter. So we're really thrilled to have you, Adam. Supreme Court correspondent for the New York Times. Adam's also an attorney. He joined the Times staff in 2002 and began covering the Supreme Court in the fall of 2008. He also writes a sidebar on developments of the law since 2007, so he is really the preeminent person to speak to in these issues. His series on the way in which the United States legal system differs from other nations, the American Exception series, was a finalist for the Pulitzer Prize in explanatory reporting. So once again, this is an all-star panel, and I'm really thrilled to welcome you all this evening to the Holder Initiative to discuss the Supreme Court. I thought what we'd do first is I want to give each one of you an opportunity to at least give your first thoughts about what this is a momentous moment for the Supreme Court with a sharply divided 6-3 kind of conservative majority as a result of Donald Trump's 3 appointments, some of which were contested, and so I wanted to give you each a chance to speak for a few minutes about what are the most important issues that we as court watchers and as educated citizens should be thinking about in terms of the Supreme Court. So I thought we'd start with Eric, and then maybe we'll proceed in the way in which I introduced you. Eric, do you want to kick us off?
Sure. Well, good evening to everybody, and I certainly want to thank our panelists for spending some time with us this evening. I think this should be a very interesting conversation because I think, as Bernard said, this is a consequential time. This is a momentous time for the Supreme Court. Now, how consequential, how momentous, I don't think we know at this point, but certainly on the basis of some of the actions that the court has taken, very, very recently, I think we're getting a sense that this court, this new conservative majority, is prepared to flex its muscle, and how that will end up, what areas of the law this new court will touch. We can speculate at this point, but I think we can make some informed speculation. So it'll be interesting to see what the people who frankly are more expert at this than I will say about the direction of the court. I really do think that one of the things that gives me concern is that I do think that the legitimacy of the court and the legitimacy of our process is really at stake. If we start to see a reversal of long-standing precedents, not because of seriously changed circumstances, but because of a change in court personnel, the makeup of the court, that will do a great deal to undermine the legitimacy that the court has, and further expose it to being charged with or being seen as a political institution. I think, of course, far more political than people perhaps are willing to admit, or that we're taught maybe in law school. But I think you can only go so far in that political, being a political institution without putting at risk your legitimacy. And so my hope would be that for the justices, as they are in the process of considering what power they have, what abilities they have, that they would keep that in mind. We often said in the executive branch that just because you can do something doesn't mean that you should. And I would hope that some members of the court would have that that same feeling. But we'll see. And I think, as I said, it'd be very interesting to hear these very experienced practitioners and observers, to hear what it is that they think about the direction of the court.
Thanks, Eric. I think that's really helpful, and I think actually we'll come back to that first when we kind of return to the questions and start the conversation. As you were saying something interesting about kind of the threat of court packing and how it might have effects on people's behavior, justice's behavior. So let's come back to that. Let me turn though to Janai Nelson to get your thoughts first.
Thank you, Bernard, and it's wonderful to see everyone and to be part of this esteemed panel on the court. I can't think of a topic that, well, I can think of a few, but I can't think of a topic that deserves more attention in this moment than the Supreme Court. I think in any conversation about the future of the judiciary, it's important to note the role that the judiciary has played, especially most recently in yanking our democracy from the precipice of disaster. You know, we just concluded a presidential regime in which a sitting president routinely and grotesquely undermined and attacked judges and the courts when he disagreed with their rulings. And, you know, this began during his presidential campaign and even before, and continued throughout the presidency. And by aggressively stacking the courts with judges that, you know, many would consider ideologues, he has left the federal judiciary in a very compromised state in which polarization threatens the efficacy and the integrity of this critical branch of government, as Eric alluded to. The relationship between courts, you know, who operate as the bulwarks of our Constitution and other laws, the relationship between courts and the individual litigants and entities and state actors that we expect, you know, almost without questioning, will respect their judgments, whether people agree with them or not, has been made so much more precarious in recent years because of the perceived, the perception that the court is not actually as impartial as it should be. It's also therefore made it even more incumbent upon the judiciary to appear and ultimately to act a fiercely non-political, independent entity. And I fear that if the court does not act in this way, there'll be an erosion of the separation of powers that will threaten our democracy in unprecedented ways. In some ways, there's much to be encouraged about when it comes to our judiciary. When it was stress tested following an onslaught of baseless litigation seeking to overturn or at least call into question the result of a free and fair presidential election, the courts stood firm. Even those judges appointed by the challenger stood firm, including the Supreme Court, in denying a suit brought by Texas and 17 other states to challenge the election results in several battleground states. So I'm encouraged by what we saw there, but those cases are at the extreme margins of the court's institutional credibility. There are many more issues that would not seem like such obvious political acquiescence or social engineering that we really should be worried about. We saw this week that the court is taking up an issue of taking up a case involving reproductive rights. We know that there are grave concerns about what the court might do with voting rights and qualified immunity and First Amendment protections of speech and assembly for protesters, affirmative action, workplace discrimination, LGBTQ rights, the death penalty. There are various and sundry matters that so many of us who do the work of civil rights are deeply concerned about this Supreme Court and this federal judiciary, frankly, adjudicating. And so I would say that the future of our judiciary is really in the balance, both in its composition and in its status in our society. And that puts our democracy and the constitutional ideals and civil rights protections that we hold dear in a very vulnerable position. I'm hoping we'll have an opportunity to talk about what would bring credibility to the judiciary and the real opportunity that this administration has to make an impact in this regard. And that is through more diverse appointments. And I hope that we can talk more about that, because I think that will be critical to saving the integrity of this court and to restoring it in the eyes of the public, and ensuring that it does act as a non-political entity.
Thank you, Janai. And definitely we will be coming back to that along a couple of dimensions, because I have no doubt that the issues of race relations in this country, and also the movement for Black lives, is one of the most important issues facing the country. And so that's related, I think, in important ways to what you were suggesting. And I want to come back both to the question of the appointments and more diverse appointments, but also the question of how an institution like the Legal Defense Fund kind of responds to the present composition of the court. So, and we'll get to that in a minute. Thanks so much, Janai. Justin Driver, what are your initial thoughts?
Well, thanks so much for having me. I'm really delighted to be a part of this panel. This is absolutely a momentous time at the Supreme Court of the United States. There are a lot of things that are garnering headlines right now. People have spoken about abortion. Affirmative action could well be on the horizon at the Supreme Court of the United States. I'd like to talk a little bit about something that's not on people's minds, but I wish that it were. And this grows out of my book, The Schoolhouse Gate. And it's the issue of corporal punishment in this great nation of ours and in the public schools. The Supreme Court of the United States had an opportunity to rein in corporal punishment in the 1970s, and it declined to do so in a 5-4 opinion. And, there was a strong claim that a truly sort of heinous instance of hitting students with a 2x4 arrived before the Supreme Court. And it said that this does not violate the Eighth Amendment's prohibition on cruel and unusual punishment. Indeed, this doesn't even register as punishment for purposes of our Constitution. In this context, in order to come within the purview of the Eighth Amendment, it would have to be punishment that flows from a criminal conviction. And because these public school students hadn't committed any crime, instead, the student in question, a young man named James Ingram, was slow to get off of the stage at a school assembly. And so this is, in my view, a deeply wrong-headed decision. And this is an important area, I think, because it's possible that liberals could forge a coalition with some of the Republican-appointed justices. When we think about the libertarian-inflected vision of constitutional law that is attractive to some conservatives, this is the sort of decision allowing the government in the form of the public school to strike students should make a libertarian want to jump up and down and scream. And it should also be something that someone who styles themselves a textualist should be embarrassed by. That is to say, this understanding of the Eighth Amendment as only barring cruel and unusual punishment that stems from a criminal conviction. Those last words I said, stemming from a criminal conviction, is not something that appears in the Constitution of the United States. And so when I think about what's on the horizon at the Supreme Court, my hope is that there will be some areas, including corporal punishment, where liberals can find common cause with Republican-appointed justices to bring about needed reforms to our constitutional order. In my mind, there's nothing that's more urgent than preventing the government from striking public school students with foreign objects. That is, in my view, a true stain, and it will come as no surprise to many on this call that students of color receive a disproportionate share of corporal punishment. And so this is a really important issue, and it's one that doesn't receive enough attention. And it seems to me that it's necessary for the Supreme Court to get involved in this area, because the jurisdictions that retain that practice at this late date are not, I fear, going to abandon it of their own volition.
Thanks, Justin. So those are two important topics that we're going to get back to. The first one you mentioned was affirmative action, which we really need to explore, kind of the future of affirmative action at the Supreme Court, and then the future of the Eighth Amendment. I admire your hope and your sanguine view of creating favorable majorities on that. Let me stop there. Okay, Adam Liptak, your preliminary thoughts before we jump into the conversation.
I think it's great to be here with you, Bernard, and with everyone. A real pleasure. We're really at a different moment in looking at the Supreme Court than has been the case in our adult lifetimes. The Supreme Court has for a long time tilted right, but it has, since at least the Reagan era, had justices in the middle, generally conservative, but nonetheless were capable of surprising you. First O'Connor and Kennedy together, and then Kennedy. And then very briefly in the last term, where Chief Justice Roberts became the first Chief Justice since the 1930s, also to be the median justice, the swing justice. And in that role, and probably, at least in part, as a result of his commitment to being the custodian of the court's legitimacy, authority, and prestige, he occasionally surprised some of his conservative allies and supporters in cases on abortion, gay and transgender rights, DACA. And so you had a court that was of the mold that we're used to. Tilt's right, but in the middle of the court was a restraining force that would lead the court to come to what many people would think were balanced decisions. Something for one side, something for the other side, respect for the court. We now have a different court. We have a 6-3 majority, which has thrust the Chief Justice out of that median spot, looks like turned over to Justice Brett Kavanaugh. And that court seems to be primed to really move, to really do stuff. And I might have thought that given the existence of calls for expansion of the Supreme Court and the creation of the Supreme Court Commission, the court might be tentative, drawing lessons from the FDR court backing scheme, which didn't succeed on its own terms, but many, many people think did succeed in chastening the court and in influencing its decisions to start to uphold FDR's New Deal programs. What we've seen in the past month or so, with the addition of cases that couldn't be bigger, one on the scope of the Second Amendment right, whether it gives you the right not only to have a gun for self-defense in the home, but also to carry a gun outside for self-defense. Huge question. And then just on Monday, what can only be thought of as a direct challenge to the viability scheme announced in Roe and reaffirmed in Casey, a big abortion case. So one thing that seems pretty certain is that this Supreme Court is not afraid that the political branches will clip its wings. Maybe one last point. We have 3 justices on the court appointed by a single president, Donald Trump, over the course of just 4 years. Compare that to the previous 8 years of the Obama administration, 2 justices. The previous 8 years before that of the George W. Bush administration, 2 justices. So over 2 8-year terms, 2 each, over 1 4-year term, 3. Something's wrong with that picture. That the fact that so much of the fate of the nation turns on the happenstance of when justices choose to retire or the happenstance of when they die doesn't seem like the way to run a mature democracy. So those are some preliminary thoughts.
Wow, no, really, really helpful and really insightful. I mean, I think that's really useful to understand what is so momentous as being this kind of like shift from years or decades of a structured court with people who could play a middling role, right, to this 6-member conservative majority. Yeah, that's right. And you didn't mention Souter, of course, who was one of those precise kind of justices who kind of came in as a conservative justice and then swings in a different direction. Yeah. Thanks so much, Adam. So we'll come back. We'll come back to that. In fact, we're going to kind of turn to that right now. I mean, so the first area I wanted to explore was the macro political issues surrounding, in part, the commission, the new commission. So, Justin, I'll keep you out of this just so that you're not, violating any norms or anything. But the new commission now, Eric, I want to start with you. You were suggesting in your early comment that the fact of the existence of the commission, or the possibility of reconsidering questions of court packing or size and et cetera, should have a kind of a chastening effect on the justices, which it did back in the 1930s, clearly. But do you think that that's the most say progressives can hope for from this commission? And so let's start there, and I'll bring Janai and Adam on this as well after you, Eric.
Yeah, I'm not. If I said that, I did not mean to say that. I don't.
I was reading a little bit. I was reading a little bit between the lines, maybe, but that's kind of like how I interpreted what you were suggesting. That
I think you picked up the wrong Eric Holder book, because I'm not. That's those lines that I think don't exist in my way of thinking. I think the commission is something that's worthwhile. I would hope that it looked not only at the Supreme Court, but at the federal judiciary writ large. There are larger questions than just the Supreme Court, though that obviously is, extremely important. But to the extent that the court could count in the 1930s and be, sensitized by the court packing scheme, the needs of the nation, I think we're in a fundamentally different position. Now, I think the court can count here as well, and they can see that nobody's going to get to 60, in terms of court expansion, however desirous that might be. So I'm not at all certain that the existence of this body is going to have an impact, on the court. And I think it's interesting to listen to Adam. We had Justice O'Connor. She was the swing vote. A little further right, then it was Justice Kennedy. Well, we go a little further right, and it's it's the Chief Justice. At this point, so let's say the chief, for whatever reason, becomes a dyed-in-the-wool liberal. Okay, that gets you to 5-4, and those 5 are, again. Justice Kavanaugh's young in terms of his time on the court. Justice Cooney Barrett, obviously young in terms of her time on the court, and who knows where they'll end up. But I think we have a pretty good sense of their judicial philosophy. They were on the courts of appeals, and we have a good sense of what kind of judges they are. So it's I think we're facing something that we've not seen in our lifetimes. We've had a court that has generally leaned right, but I think the leaning that we're going to see over the course of these next few years, next few decades, I don't know, is going to be something really fundamentally different than that which we have seen before. And the existence of the commission, the threats of expansion. I just don't see that changing what I think this court is poised to do in a whole range of areas.
Mm-hmm, mm-hmm. What do you? So reading between the lines again, or maybe let me ask this. I hear you saying that this may have some effect on the lower federal courts, but unlikely that the commission is going to have a major effect on the Supreme Court in terms of its structure.
Well, but I think the potential is there to have an impact on the lower federal courts. If, for instance, a determination is made that there is on a needs basis, we should expand the lower courts. We've not done that for a couple 2-3 decades. And there are legitimately, some courts that are in emergency situations. Things are not moving through the dockets at the Court of Appeals level, at the district court level. And if that is one of the recommendations that comes out of this body that is then, followed up on and legislation is passed, that could have an impact on, I think, the lower courts. So I think you could see the lower courts expanded, for lack of a better term. But the possibility that the Supreme Court goes beyond 9, I just don't see how that happens.
What about things like possibilities for term limits, or let me bring some other folks in. Janai, Adam, what do you think about the possibilities for kind of term limits or other changes, perhaps to the shadow docket? We can talk about that as well.
Well, I'll say I tend to agree with Eric that it's not clear to me that the commission will be able to make recommendations that can ultimately make it through Congress. But what I do hope will happen is that it will serve an educative function, so that the public will understand the operation of the Supreme Court better, will understand what alternatives exist, whether they're able to be adopted or not, and that will create, to some extent, a sense of accountability, by members of the court to act with, impartiality, and again, to go to greater lengths to ensure that there's no appearance of partiality, and that they act as more of a clear and independent entity. I do think there is real possibility in lower courts that we've had access to justice issues that have persisted for years, where dockets are unevenly distributed across the circuits and across the courts and across different chambers. And so I think there is some real potential for there to be reforms at the lower level of our federal judiciary, and that should not be underestimated. We know that the Supreme Court does not grant cert to very many cases. So many of the critical decisions that we all care about will be decided at the circuit court level. And that can actually be incredibly important as we shape doctrine in different areas of law. Not everything is going to go up to the Supreme Court. So the possibility of reforming lower levels of the judiciary, of the federal judiciary, is actually quite helpful and shouldn't be underestimated. But I do share the doubt that we're likely to see any reconfiguration of the court through changing the structure of it in any way.
Right. And of course, as Eric was suggesting, in part because of the vote count in the Senate, and so it would be hard to imagine already getting to 50 on a court packing scheme, but you'd also have to get rid of the filibuster in order to, even if
that's right.
The case, possibly. Adam, what are your thoughts about the
So briefly on expanding the size of the lower courts, there is a good neutral principle, non-political, non-partisan judicial administration workload argument that we need more judges in the lower courts. There's no such argument in the Supreme Court. The Supreme Court is set to decide like 58 cases this year, which is the smallest number since last term, and then before that, since the Civil War. So this is at least on the merits docket, not a hardworking court at all. On the question of term limits and expanding the size of the court, there's an odd disconnect. Expanding the size of the court is a political move. And might give rise to tit-for-tat retaliation and is problematic for those kinds of reasons, but is at least constitutionally quite easily achievable. Congress has the power, if it wants to increase or decrease the size of the court. It's done so repeatedly. The court has been as small as 5, as large as 10. So it can be done. I agree that politically it won't be done. And I think there's a political argument that it shouldn't be done because it'll just start a tit-for-tat war. The much more sensible reform is term limits or mandatory retirement ages, which every single developed democracy has. We're alone in this idea that people should serve into their 80s and decide for themselves when to retire, which injects an element of politics onto the back end of a process that starts, it's rooted in politics. So the Constitution makes appointment and confirmation a political process. It assigns those roles to the president, a politician, and the Senate, 100 politicians. So we already have politics on the front end. To have it on the back end with justices making calculations about trying to retire under presidents whose ideologies they approve of is really hard to justify. But, and this is somewhat contested, but the consensus view is to make that change, which really, if you did it in a kind of grandfather behind the veil of ignorance kind of way, doesn't necessarily benefit one side or the other. That probably would require a constitutional amendment, which makes it very hard to achieve as a practical matter.
Although at this point, given the configuration of the court, wouldn't it, I mean, we wouldn't be behind a veil of ignorance. Wouldn't it be very much opposed by Republicans putting term limits? I mean, the younger members of this court are Trump appointees, right?
Yeah, so say you grandfather in everyone who's sitting on the court now. Mm-hmm. And with, it kicks in with each subsequent, and it would take a long time to come into place. And it wouldn't solve any of the current problems, but it would be a sensible thing to do.
Mm-hmm. 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 Good. So Justin, I want to bring you back in the conversation. I should note for all of our viewers, we will be taking questions in about 30 minutes. So if you have any questions, email them to holderinitiative@columbia.edu. we'll be assembling the questions there, and then I'll be posing them to our guests. So again, that's Holder Initiative, no periods or anything. Holder Initiative at columbia.edu, and go ahead and send your questions there. I'll come back to you, Justin. So let's deal with some of the substantive issues, and the one I wanted to start with was affirmative action policies at the Supreme Court and what the future might hold for that. And what's your sense of that?
Yeah, so this is a matter that's before the Supreme Court right now. There is a cert petition involving Harvard University's admissions practice and a claim that it violates Title VI of the 1964 Civil Rights Act. And many people are concerned about the future viability of affirmative action. I think many people would say that affirmative action is, sort of hanging by a thread. And what's interesting to me is that affirmative action has been thought to be hanging by a thread since at least the 1970s, and Justice Powell's decision in Bakke of 414 decision, where Justice Powell, one of these Republican appointed justices, who makes an improbable savior of affirmative action. That's true for Justice O'Connor in 2003 in the Grutter decision. And of course, Justice Kennedy in the Fisher case, another Republican appointed justice. All three of these are Republican appointed justices who have nevertheless said that affirmative action and race conscious admissions policies do not violate the Constitution of the United States. I do think that it is exactly as many other people have suggested, that the justices on the current court often have a different profile than, say, Justice Powell or Justice O'Connor or even Justice Kennedy, in the sense that they often have experience working in a presidential administration. These are sort of creatures of Washington, D.C., in a way that, Powell and O'Connor and Kennedy and Souter and these other Republican appointed justices who have drifted leftward over time were not. When Justice O'Connor wrote her opinion in Grutter, she wrote this statement that in 2003, she writes, it's been 25 years since the court decided Bakke, and in another 25 years, it's sort of unlikely, or, affirmative action will no longer be necessary. I think that at the time, many members of the civil rights community thought that's way too short a time period. It's going to take longer before race conscious admission practices are no longer necessary to the quest for racial justice. But here we are 7 years away from 2028. And I think that many people would say, I hope there's another 7 years, because if the current court grants certiorari in this Harvard affirmative action case, it might be around for only another 2 years. It seems improbable to me that Roberts or Alito or Thomas are going to, sort of do an about face on this issue. And I do think that the three Democratic appointed justices are almost certainly, going to vote in favor of race conscious admission practices. And then that means you have to find two people among Justice Kavanaugh, Justice Barrett, and Justice Gorsuch, and that is some very tough sledding, I think. Indeed, Justice Kavanaugh, before he was on the bench, has written quite harshly about race-conscious, governmental decision-making. It is interesting to me to think about what universities would do in the aftermath of a decision saying race-conscious admission policies are no longer viable, and how they would manage that. I do think that this notion of diversity on campuses is quite deeply felt among many institutions of higher learning. So it would be fascinating to think about how universities and colleges would respond to a hypothetical decision invalidating something that we've lived with for more than 40 years now, right? I mean, it is firmly embedded in the American higher education landscape.
Right. Janai, let me bring you in on this conversation, not only to think about kind of the future of affirmative action at the Supreme Court, but how does the Legal Defense Fund change its strategies or kind of develop strategies to deal with a federal judiciary that obviously is kind of stacked against the positions you're usually taking?
Yeah, that is a great question. And I think it's important to put the question of our comfort in bringing racial justice claims, whether they be about affirmative action or other types of claims, before the Supreme Court in historical context, because I think Adam alluded to this. It's been quite some time since we felt any measure of certainty, to the extent you can ever have that with the Supreme Court, but any sense of comfort that the issues of systemic racism and racial injustice in which we traffic would be decided in our favor. If you take, for instance, the landmark decisions in Brown versus Board of Education, which ended state-sponsored segregation in public schools and ultimately led to the disintegration of the legal separation of the races. We celebrated Brown's anniversary this week on Monday, the 67th anniversary of that decision. And I've got to think that when Thurgood Marshall and Robert Carter and Jack Greenberg and Spotswood Robinson and Constance Baker Motley and all the other visionary lawyers that comprised the dream team conceived of that legal strategy to bring Brown to the court, that they had to, at a minimum, expect that they would get a fair hearing. And to think about what an audacious task that was, to ask the court to overturn Plessy versus Ferguson, which was decided 125 years ago yesterday. They had to, at a minimum, believe that the Supreme Court would be amenable to an expanded reading of the 14th Amendment, and that they could build on earlier precedent challenging segregation in higher education, like the Seville case and Sweat v. Painter and McLaurin. But these days, it's very hard for civil rights litigators to have any expectation that the claims we bring will be treated with due respect and an open mind in the way that our forebears had some faith and some reliance on in the court. The Warren Court lasted through 1969, coinciding with the end of the civil rights movement, and a conservatism set in, and we saw that in cases like Bakke, as Justin mentioned, and additional cases that followed, like Adirondack contractors applying strict scrutiny to all racial classifications, and in the voting context with Shaw v. Reno, hindering the creation of majority-minority districts. And fast forward to today, where we have a supermajority of conservatives on the court, that includes some at the extremity of the conservative spectrum. And there's a willingness, as we just saw earlier this week, to overturn and ignore precedent. Just this week, the court did away with Teague, with the retroactivity standard. And it's deeply concerning. It seems that there's a virulent strain of protectionism for corporations and political parties. And as a racial justice and civil rights litigator, the option of redress by the highest court in the land is not something that we can count on. And we have the tough decision of trying to steward our cases in a way that preserves the wins that we have, and does not expose them to being overturned or undermined by the creation of bad law.
Mm-hmm. But does that mean, for instance, that in terms of ongoing litigation or litigation campaigns, that you reorient towards state courts, or how do you, in terms of I get the idea that you're going to have to preserve some of the good case law that was achieved over time, and there's no alternative but to try and do that in the federal courts. But does it mean, as a kind of a larger, broader strategic perspective, that you focus on different kind of work or different courts or something?
Well, there's an increasing, I think, openness to litigating more in state courts. And look, we don't control the field, right? Back when Brown was decided, the Legal Defense Fund was the active litigation shop in the civil rights ecosystem. Now there are many other organizations bringing suits. There are other organizations that claim to be operating in service of civil rights, but are doing quite the opposite, that are gunning to get to the court. And we see that in the affirmative action context. So some of this is beyond our control, and we obviously will litigate as fiercely as possible before the Supreme Court and any other forum. But I do think that there's a strategy that requires us to think very, very carefully about cases that may ultimately go to the court. And again, as I said earlier, so few cases actually get to the Supreme Court that there's still a lot of work to be done at the circuit court level. But if we look at the composition even of the circuits, they are deeply concerning, and considering the number of appointments that occurred, or confirmations that occurred in the last administration, we are wary even at the circuit court level, and particularly in certain circuits that we know are hyper conservative. Thanks.
Right. So, quick question to Adam, and then I want to go to you, Eric, on this question actually about, I mean, as the head of the Department of Justice, were there kind of revisions in terms of strategies that you were making, given the composition of the court? But Adam, quickly on the Harvard case, as you know, our best court watcher and maybe best predictor, what are the odds? What are we betting on here?
Oh, well, the odds of them taking it extremely high. The odds of the Harvard program being sustained extremely low.
Okay. Has it been kicking around from conference to conference? Is that why you're?
No, it hasn't been conferenced yet. We just had yesterday Harvard's brief in opposition, and my predictions are not grounded in legal analysis. They're grounded in what you might call political reality.
Okay. All right. Okay, boy. All right. Well, that's a harsh political reality. Eric, given harsh political realities, how was the Department of Justice changing its strategies in view of an increasingly conservative Supreme Court, and also increasingly conservative federal courts as well, lower federal courts?
Yeah, I mean, the department doesn't necessarily have the degree of flexibility that frankly I have now as the head of the the National Democratic Redistricting Committee. Now I'm looking at just a narrow set of things at the NDRC. I mean, the Justice Department has got to try to deal with the court, as it is, try to come up with ways in which you can argue to one or two justices to try to get to a good result. If you're the Solicitor General now in a progressive administration, I'm not sure who do you argue to, at the NDRC, by contrast, the Supreme Court says you can't bring partisan gerrymandering cases in federal court. Okay, we'll bring them in state courts. And we've been, pretty successful in doing that. And I think that for progressives, we have to rethink. I mean, we still have to be as strong as we possibly can be in the judicial setting, in the court setting. But I think we've got to reorient ourselves and be more engaged in the political process, and elect people at the state level, especially at the state level. Progressives, we're all about, and Democrats, we're all about, who's president? Oh, it's great. Who's senator? Well, who's governor and who serves in your state legislature. So we've got to become more active and more effective there. Now, there, of course, you're faced with these counter-majoritarian things that are being done by the opposition in terms of voter suppression, gerrymandering. I mean, these are all things that we've got to get at, and it's why we're not talking about that tonight, but it's why the For the People Act is such an important piece of legislation. But the thought that the court might be a place where progressives could pin their hopes, and that could be the place where justice in a whole range of contexts could be had. I just don't see it. And I don't see it happening now and for an extended period of time, which really means, as I said, that we've got to rethink the ways in which we try to come up with progressive solutions to things that have bedeviled this society for far too long. And one of the other dangers for the court is, if it's interesting, Congress may change, state legislatures may change, presidents obviously do change. But if the court stays in its present posture and its present outlook, it'll get, I think, increasingly more separated from what the American people want, where the political zeitgeist is. And at some point, you almost will think that you've got these, these old, they'll get old at some point, these old justices kind of, bang at the moon or something, but with huge amounts of power that will still reside there. And I worry about that. The notion that the court could become disconnected. You don't want the court to be susceptible to popular will, and yet at the same time, you don't want it to be totally divorced from the people that at the end of the day, the court is supposed to look out for, the court is supposed to, in some ways, serve.
Right. Yeah. I mean, but those are difficult realities for lawyers, for progressive lawyers,
right,
who have been kind of trained in this tradition of litigating and raised on the hopes, the Warren Court lore of the Warren Court. I mean, those are harsh realities for institutions like LDF that are made up with litigators, right, and lawyers. So to kind of, I mean, in its most crudest way, to say, okay, we got to pivot from litigation strategies back to politics for progressive causes. That's tough to swallow for a lot of people.
Yeah, I get that. I mean, I understand that it's tough to swallow, but in terms of where we've got choices, where we're examining options, not defense. When you're playing defense, you do all that you possibly can. There's going to be a lot of defense played. Understand that. But when you're deciding, offense, where is it that we're going to go to try to affect, positive change, and what's the result of this offensive action that we might take? That has to be a part of the calculus. I mean, how likely are we, to win? Now, I mean, at the Justice Department, I remember we had people recommending that we not challenge the Arizona immigration bill, and I thought, this is one we ought to take a shot, and it worked out fine. That's not necessarily, those that kind of one-off there. I think it's hard to see how you can replicate that on a fairly kind of consistent. You can win more than you can lose with the ideological makeup of this court. And just one last thing, I don't want to dominate it, but one of the things that really sticks in my craw is that after Justice, we should have had, with Justice Merrick Garland, we should have had at least 4 years or so of a majority progressive court. And so, in addition to whatever happened to Merrick individually, and that bothers me, he's a great man and he would have been a great justice, there's 4 years that the court would have had for the first time, I don't know, whatever number of years, a progressive majority. And there were a bunch of cases that happened that would have been decided in a different way, not the least I talked, the Grucho case with regard to the decision on partisan gerrymandering. That might have turned in a different way, and that would have had, all kinds of collateral impacts.
Right. Justin, I think I can bring you in on this because I think it's not necessarily in the purview of the commission here. And then I want to get back to you, Adam, on the big cases that are in some way going to shape the controversies around the court. We've spoken about a few, but I want to get your opinion about others. But Justin, what do you think about this? About whether one pivots or how one addresses the political reality of the Supreme Court and its present 6-3 majority and the lower courts as well that are kind of very conservative now?
Yeah, I would say a couple of things. One is that, this trend that Eric and Adam have identified as something that stretches back a very long time. The Warren Court is, ancient history now. It ended in 1969. And since Chief Justice Berger joined the court, there have been, by my count, 20 justices who have been confirmed, and a grand total of 4 of them are appointed by Democratic presidents, right? We're talking about a tiny group of people. In fact, there were 11 in a row that were Republican appointed justices. I'm talking about the space from Justice Thurgood Marshall in the late 1960s to Justice Ruth Bader Ginsburg in the early 90s. Every single one of those justices was Republican. In some respects, but the marvel of our constitutional order is not that it's so conservative, but that it's not more conservative still, actually. What does a progressive do? I think that turning one's attention to state Supreme Courts makes a lot of sense. You can see this having paid some dividends with respect to school finance litigation in the aftermath of the San Antonio Independent School District versus Rodriguez decision from 1973, where Justice Marshall says, you've lost in federal court, you should take your business to state Supreme Courts interpreting the state constitution. And that has paid some dividends. And I'm also sympathetic, certainly, to what Eric says about paying less attention to the courthouse and more attention to the state house, right? And it seems to me that there are these outlets. It's important to remember that the Constitution of the United States and the Supreme Court of the United States, I should say, is responsible for establishing some sort of constitutional floor below which states and localities and the federal government cannot fall, but nothing prohibits states and localities from offering additional layers of protection to marginalized communities. So I don't think that the composition of the current court means that all hope is lost. And the last thing I would say is where I began, which is it does seem to me that it is incumbent upon liberals to try to find some common ground where it may be available to win victories in the Supreme Court of the United States, and there are some opportunities, it seems.
Yeah. I mean, in the area where I practice mostly, in the death penalty area, I mean, there's no question that there's been a turn towards the states trying to address the death penalty at the state level by state courts, by state Supreme Courts, whether it's Washington State Supreme Court that held the death penalty, unconstitutional under the Washington State Constitution because it was racially discriminatory, or the attacks that are going on right now elsewhere, whether it's in Kansas and North Carolina, et cetera. There's no doubt that, at least in that context, there is little hope that there would be much achieved at the federal level, and given the decision on life imprisonment without parole that just came down, Jones versus that just came down from the Supreme Court just the week before last, which kind of takes this much harsher view on punishment, allowing life imprisonment without parole for juveniles. I think, and this does intersect again with the question of corporal punishment. I think that it's going to be a tough road in federal court. And so one of the major ways of approaching it is to turn to state courts and state constitutional law, at least in the death penalty context. But Adam, go ahead, Justin.
I was just going to say very quickly, it does seem deeply regrettable to me that on the current Supreme Court of the United States, there are not people with a history of public defenders. It's really quite instructive that the leading voice of the left on criminal justice matters is Justice Sotomayor, a former prosecutor, right? And I have heard, President Biden making some strides toward trying to put public defenders on the federal bench, and that seems to me long overdue. It's our conversation, our national sort of constitutional conversation is so sort of skewed in this area. So I do think that this is an instance where one appointment might be able to make an enormous difference in terms of the range of what's possible in this area.
Well, let me just for 30 seconds stick up for prosecutors here. Yes, we do need to have a more diverse bench, and I'm all for having criminal defense attorneys be judges and justices. But I don't think we should look at prosecutors and think that reflexively all of us who once were prosecutors are going to rule in a certain way. I think I did a lot of stuff with regard to criminal justice reform, and I've been nothing but a prosecutor. So I'm for, I'm for inclusion, but I don't want to exclude on the basis of, past service.
Well, right. I'm putting in plugs. I'm going to put in a plug for civil rights advocates as well, because there's a distinction between federal public defenders and civil rights practitioners. And that need to diversify the bench on that level has not yet been met. And I know that is something that we have long advocated for. You would be hard pressed to find the likes of Thurgood Marshall and Constance Baker Motley on courts across the country. And that is something that absolutely needs to change.
Yeah, for sure. I mean, I think, Eric, it's a question of kind of like such vast disproportion that it's not a question of excluding prosecutors. But I mean, in most, both at the state and at the federal level, being a prosecutor is kind of often a stepping stone to being a judge. At least where I practice in Alabama, that's, you were a district attorney, you were in the district attorney's office, and then you run for judgeship and you get elected as judge, and that's just it. I mean, and the number of, so it's so vastly disproportionate that it's not a question of excluding anyone. It's really more a question of kind of, a few bones or something like that.
I'm just looking out for my peeps. That's all.
I hear you. Me too. But I would say that we see with the Biden nominations that have been coming out, we have seen a real emphasis on defense, on criminal defense.
That's a good thing.
So yeah. Adam, I did want to get to. So what are the big, and we've got questions rolling in. Again, if you have questions, you send it to holderinitiative@columbia.edu. Okay, and we've got some great ones here that I'm going to get to in a minute. But I did, Adam, want to get to what are the major decisions that in some way are going to play such an important role at shaping the political conversation about the Supreme Court and its structure in the 12 months. The commission has to give its report in 180 days from today, since the commission met for the first day today. So there'll be a report in 180 days, but the conversation's obviously going to be ongoing over the next couple of years. We've talked about the abortion case that they just granted cert in, and the gun control case out of New York. What are the other, and of course we just spoke a little bit about the affirmative action Harvard case. What are some of the other cases that you think are going to shape the conversation?
So Bernard, those are all cases that'll be decided the next term. So those are cases that'll land in the spring or summer of 2022 as the next midterm elections go underway. This term, the term that ends in June, I'm going to quickly tick through very quickly 4 cases because collectively they give you a sense of the court. One, the court is very likely to reject the latest challenge to the Affordable Care Act. And that's a gift to them from the red states that challenge the law on implausible grounds, because it will give the court an opportunity to appear apolitical and to reject what is a convoluted and far-fetched legal theory. So that will make headlines, and that will make the court look even-handed. The court will also continue what we've seen through the last year, through the pandemic, its engagement with religious liberty, and it'll decide a case on whether the city of Philadelphia is free to insist that organizations that screen foster parents must not discriminate against gay couples. And there I predict that it's going to be quite aggressive in employing the free exercise clause to overcome protections for gay rights. And that case, called Fulton, in many ways may be the most significant of the term. And then there are two cases that I hesitate to describe in too much detail because everyone else on the panel probably knows more about them than I do. One of them is a look at Section 2 of the Voting Rights Act. We all know that in 2013, the court effectively struck down the heart of the Voting Rights Act, which requires jurisdictions with a history of race discrimination to get federal preclearance for changes to voting procedures. But the court left in place Section 2, which allows after-the-fact challenges, and has never said anything about the scope of that right in the context of restrictions on voting itself. The court is looking at two restrictions in Arizona, one on the process critics call ballot harvesting, the other on what happens if you cast your vote in the wrong precinct. The outcome of those particular restrictions, not super important. The Biden administration has filed a letter saying it could live with the restrictions. But what the court says about whether Section 2 has teeth, having eliminated Section 5, whether there's still some recourse to go after efforts to suppress votes based on race discrimination, tremendously important. And that'll probably be a fairly nuanced and divided decision, but worthy of a lot of attention. And then finally, I think I'm going to kick over to Justin, an important student speech case called Mahanoy School District against a student known in court papers as BL, which looks at the question of, can schools punish kids for off-campus speech?
Yeah. Justin, you want to say a word about that one?
Sure.
That was the cheerleader, right? Who said something about cheerleading team or something.
Oh, yes, indeed. So it's a really important student speech case, the most important since Tinker from the 1960s, which in the context of the Vietnam War, some students wanted to wear black armbands in protest of the Vietnam War. And the school officials said, no, that's too hot. And the question was whether students had First Amendment rights at all. There, Justice Fortas writes an opinion where he says, it can hardly be argued that students shed their constitutional rights at the schoolhouse gate. This is sort of a resonant phrase. And this question here, exactly as Adam suggested, is, well, what rights, free speech rights, do students have beyond the metaphorical schoolhouse gate? Everyone acknowledges, certainly in the age of Zoom learning, that it has to be about the school setting, right? And the school setting sometimes exists beyond the schoolhouse gate, but surely I would have thought there needs to be some space for students to be able to blow off steam on an afternoon. In this particular case, a young woman called Brandy Levy was cut from the varsity cheerleading squad, and she wrote a Snapchat message where her middle finger was extended toward the camera, and she had a number of expletives, including, she said, F cheer, only she didn't say F, right? The school officials get wind of this and they cut her altogether from the junior varsity team and suspend her and say, you can't even be on the JV team. The question is whether that was permissible to punish her for that in this way. And the core question is whether the rule that comes from Tinker is going to be applied to off-campus speech. Tinker gives students watered down free speech protections while they are in school, but it's better that they have some protection there than no protection at all. And the question is whether it's permissible to sort of apply Tinker to off-campus speech. For my own part, I find it quite improbable that a student saying F cheer is going to lead to anything like a reasonable forecast of a substantial disruption. The idea that the students couldn't, form the pyramid in the proper way, or that this was going to sort of be devastating to the morale of the team, I find very difficult to fathom. And if I were to hazard a guess, I would think that the court will offer a very narrow rule here, which may say something like, even assuming that the rule of Tinker applies to off-campus speech, it was not reasonable for the school administrators here to say that there would be a disruption and therefore this particular speech was protected by the Constitution of the United States and the school acted impermissibly. However, that ruling, such a ruling, would be disappointing to many people who have thought about these issues, in part because school administrators are in desperate need for some guidance in this area about when they can punish students. And the lower federal courts have also been wrestling with these issues over a long period of time. And if the court were decided in the narrow way that I'm suggesting, that clarity would not be forthcoming.
Thanks. All right. So I think we've got a good landscape there of what to expect in the next few months, and then of course those other certs for next year that'll be driving the narrative, I think, about court change and court structure, abortion, gun rights, etc. Okay, we've got a bunch of questions coming in, so I want to bring those forward. Make sure we include our brilliant students. I've got two questions basically about the Shadow Docket. I've got one from Olivia Choi, who's Columbia College 23, and one from Isidora Ryder Harcourt, who's Barnard 2016. And actually, that's my daughter. She's graduating from, Justin's been teaching her, and she's graduating on Monday.
Wonderful student, a wonderful student.
And they both have to do with the Shadow Docket, which, Adam, maybe you can give us a quick background on that. Here, let me just read Isidora's. It's very frequently used to reject death row petitioners' last attempts to challenge their executions. And so they're very short, 1 or 2 sentence denials of cert late at night and the night of executions. And that raises real questions about the fairness and the way in which precedent is being made in these cases. So Adam, why don't you give us your thoughts about that and whether that's likely to change at all? I know it's part of I think it's part of the review commission. Go ahead.
Yeah, I think it is too. The Shadow Docket is a term coined by Will Bode of the University of Chicago Law School to refer to everything the court does that is not part of what we usually think the court does, which it grants cert, gets another set of briefing on the merits, hears arguments, spends months exchanging drafts, and finally gives rise to the merits opinions that we're used to. And it does that these days 58, 60 times a year. It does a lot of other stuff too. And primarily what the Shadow Docket these days refers to are emergency applications filed on very short notice. And they can be very consequential. Last minute requests for stays in death penalty cases are nothing new. And people have argued about whether they were adequately treated or not. But the rise of the modern Shadow Docket really comes out of the Trump administration's scores of efforts to get before the Supreme Court any loss in a lower court, and particularly loss, in fairness to them, involving the imposition of a nationwide injunction shutting down one of their programs. And it turns out that in this very abbreviated form, where you just have, in the space of 4 days, a week, a set of thin briefs, no arguments, no meaningful deliberation, and a decision that often contains no reasoning and just a line saying injunction granted, stay denied. You have enormously consequential decisions being made about COVID programs, about transgender rights in the military, about the border wall, about countless issues that are easily as big as things being heard on the merits docket. And you get something that I guess is a precedent, although there's often no reasoning or very thin reasoning, so you don't know what the precedent is. You generally don't even know what the vote count was. And if the court claims its legitimacy through reason is lacking in this stuff. And we've gone through 4 years where lots and lots of decisions were made in these days. Now, as Eric was suggesting, I hope I'm not reading between the lines, the Biden administration is much less likely to run to the court because unlike the Trump administration, it won't be knocking on an open door. It will be facing a hostile court. And so it may not file as many emergency applications, but other groups may still. And, the Supreme Court's work, whatever else you think of it, is fully explained and subject to analysis and criticism when it's working on the merits docket. On the shadow docket, you have none of that.
Right, right. So that is part of the commission review. Actually, there's five areas of research, and the last one is issues surrounding Supreme Court's case selection and review, as well as docket rules and practices. So I think it is something that will be under review. Can't talk to that about that with Justin right now, but it's kind of the mix of the growth of the shadow docket and the shrinkage of the actual merits decisions that somehow is causing the friction or the problem most. Janai, I wanna maybe ask you to address that before turning back to Eric. But also I've got two excellent questions. So let me pose this, or let me throw this in the mix. As we think about kind of transformations to the shadow docket or other transformations, one is from Will Searcy, who I think you know, Janai, who was at the Thurgood Marshall Institute as a summer intern. Will's question is, can someone speak to the necessity of a narrative shift that needs to take place as the Biden administration's Commission on SCOTUS recommends the expansion of the court? In what ways can we be can the administration be proactive about changing the way people think about it? And in a way, this connects with a question that is from another brilliant student. I think it's from Emily Gruber, who's also asking basically, look, I mean, the court has been packed in a way. And so maybe we need to just be realistic about this and talk about these changes in a different way. What do you think about that, Janai, and also in the context of the shadow docket?
Sure, happy to take that on. And Will, it's wonderful to hear from you. Thanks for your question. I'll just start quickly with the shadow docket and talk about another exacerbating factor, and that is that the previous administration used the shadow docket at an unprecedented rate. And if you think about that, if you think about the idea that the government can request a decision from the Supreme Court and the Supreme Court issues it, I think it was at a rate of 70% in favor of the government with no explanation, no reasoning, that is a manipulation of the third branch of government in a way that undermines its integrity in ways that are deeply, deeply concerning. And the proliferation of the shadow docket is really, as you pointed out, creating such an imbalance between the cases that the court decides on the merits in the open with oral argument on briefs where amici can participate and there's a full airing of the issues, and the public can see how doctrine evolves, and you can get a better sense of the role of the Supreme Court through this public forum versus the shadow docket, which is ballooning, and there's virtually no restraint on what the court can do on that docket. It is deeply concerning, and I think another factor that calls the court's integrity into question. In terms of shifting the narrative, I think I mentioned earlier that I do believe that this commission, at a minimum, can serve an educative function, and that it can decipher some of this for the public in a way that can help shift the narrative. I don't know that it will shift the narrative enough to get us past 60 votes in Congress to actually expand the court, or even if we got rid of the filibuster, past 50. But at a minimum, it will, I hope, put a check on the court by opening up the possibilities of what the court could look like, and allow the public to question the current operation and configuration of the court with real information. So many don't fully understand the role of the Supreme Court. And you mentioned shadow docket, they have no idea what that means. But if you explain it in plain terms to an everyday citizen, that the court is issuing decisions literally that are life and death decisions in many instances, without providing any reasoning, without any check, without any public forum, I think that would be deeply concerning, and there needs to be more translation of the role of the court for the general public, and that will help shift the narrative about potential reforms.
Right. Yeah. That's great. That's helpful. That's helpful. Let me follow this strand and this conversation with Eric. The question was actually also coming from Zach Kimmel, who's Columbia College 21, one of our great students at the Holder Initiative as well. And in part, it kind of like adds a dimension to this, which is, what about just giving up on the pretense that the Supreme Court is a non-political branch? Right. From a broader process of court reform, would it be fruitful to just admit that the court is a partisan body, more akin to Congress and executive branch than we'd like to admit? I mean, what about just being realistic about this and taking that approach? I think it was just this week, Adam, you correct me on this, but I think Justice Breyer was making some statements about the importance of the kind of nonpartisan nature of the Supreme Court and the legitimacy, et cetera, which is, a conventional way that justices talk about the court. But why don't we just, why don't we stop with the nonsense and be honest about what's going on? And would that be a path forward, Eric?
No, I don't think that would be a particularly good idea. I think by holding the court out as a non-political entity, I think it probably shapes the way in which justices think of their jobs at a minimum. Now, I think we should not delude ourselves in the ways that we have in thinking that politics never has an impact on what the court does, or that ideology has no impact on what the court does. I remember the Chief Justice talking about, we don't have, Trump judges, Obama judges, Clinton judges. Yes, we do. Yes, we do. I was involved in the judicial selection, and you're looking for judges who share your worldview to become judges and to become justices. But we also expect that once selected, that they will conduct themselves in a way that is, not political. And if we were to simply say the Supreme Court is, or the federal courts are simply, political institutions, that would, we'd put at risk, a real important part of our system of government. And one of the things that worries me about this is that in the way in which we now select judges, justices, the fact that they serve for as long as they do, they get picked, like almost fresh out of law school, and we put them on the bench now. That worries me, that we are politicizing the court beyond that which I think is acceptable, the courts beyond that which is acceptable, and we do so at risk to the American experiment.
But so I'm fielding questions. I'm getting stuff on the email and getting stuff text as well. So, but the response, I take it, this, my daughter was texting me, conservatives admit the court is political. That's the platform that Trump ran on, and it works for them. Why shouldn't Democrats do the same thing? Adam.
I'm going to defend the court to an extent. The court is made up of able lawyers with lifetime appointments, with no particular incentive to be political, notwithstanding that the people who got them onto the court had high hopes that they'd be political. And they're unanimous, 40% of the time. And in cases, sometimes important, sometimes less important cases, but in cases that have surely divided the lower courts, and yet they come together as lawyers and try to come up with the sensible, workable answer to some statutory question. And that's a significant amount of their work. They're also divided, not infrequently, in surprising ways. They split on the right very often on the approach to the case, even if they agree on the bottom line. So the cases that are on the front page of the New York Times in June are sadly predictably split, and stink of politics. But that's not the only thing the court does. And while I agree completely with Eric that there's an element of politics in what they do, it's not the entirety of what they do. And insisting that it's only a political institution will do nobody any good.
Okay, all right.
Which doesn't mean, though, to respond to the questioner, in terms of selecting who should be president of the United States, that the fate of the courts is something that progressives, liberals need to focus on, and that should be a driver for political participation by voters.
And I suppose the last question is coming in from Stephen Davis, who's a graduate student in applied analytics here, and bringing in the question of what should be considered a reasonable metric in determining the qualifications. To what extent should what would be some evidence of nonpartisanship be considered a metric in determining qualifications for the court, for the Supreme Court? I don't think, maybe Janai, maybe I'll start with you on that, on this one. And Justin, I'm not sure, I think this is outside the purview of the commission, so maybe I can get to you on this one too. In other words, should in the decision-making process, in terms of the metrics to determine qualification, should part of it be a certain non-partisanship? Do you think?
Ideally, yes, absolutely. How you can measure that is the real question. There's such a static nature in terms of how the justices vote, the alignment between certain justices who vote together. I know, before Justice Scalia passed away, Justice Scalia and Justice Thomas voted in alignment in record numbers, it seems. And that could be a naturally occurring effect for justices who share the same ideology and same approach to interpretation. But you would expect some more dynamism on the court if it were evaluating each case independently, constrained, of course, by stare decisis, but you would not see such paired factions on the court. And when there's a notable departure, it's a big deal for all of us. When you see an alignment between a liberal judge and a more conservative judge, it seems to be such a shocking event. Ideally, we would see more of that. And perhaps that is some way to measure whether the court is operating in less of a partisan or political or ideological fashion and more with an impartial lens and an objective lens that it will bring to each case and that it should be bringing to each case that it hears.
Wait, thanks. Let me ask Justin if you want to jump in on
that. I do worry that the polarization that exists at the court now is going to be in existence for a sustained period. And part of that is due to the now decades of existence of both the American Constitution Society on the one hand and the Federalist Society on the other, where we have law students, oftentimes people who are 22 or 23 years old, sort of signing up for a team, and then they are handed, in effect, their sort of roster of jurisprudential commitments that they are informally pledging allegiance to for the next, several decades and everything. And that is something that's not going anywhere as a descriptive matter rather than as a normative matter. It is interesting thinking about what are the qualifications of a Supreme Court justice. And one thing that I believe 8 of the 9 of them do have is being Federal Court of Appeals judges. Justice Kagan is the real wild card here, who was only Solicitor General of the United States, which isn't exactly, a politician and elected official, as was true during the Warren Court, right, where Earl Warren was governor of California. You even had someone who went directly from academia, right, Felix Frankfurter, as long as people were sort of putting in their 2 cents for their people, as it were. So there were a wider range of professional backgrounds, and I do actually worry that having everyone come from this same sort of highly legalistic milieu constrains the conversation that happens within those walls in a significant way. And so one thing that we might get away from would be having everyone required to more or less be a federal court of appeals judge.
Yeah. No, that's a really important point. And so before we wrap up, and I'm going to ask Eric to wrap up this conversation for us in a minute, I just want to ask Adam, on this issue, right? I mean, so yeah, we did have Warren, who was a politician, right? I mean, there has been a tradition of putting people on the bench who have been politicians and not necessarily judges. And so, how do you think about this in terms of, this question of qualifications and partisanship?
Yeah, so as Justin was suggesting, the court that decided Brown had former senator, former attorney general, former governor, former law professor. And although some of them were politicians, it's not clear that being a politician leads you to political results. It's sometimes, as in the case of Justice O'Connor, who served in all 3 branches of the Arizona government, leads you to a kind of pragmatism, an attention to workability, an attention to public opinion. So it's kind of puzzling and counterintuitive that the more legalistic the court is, and the more formal and the less attuned to policy, the more likely its decisions will be perceived to be political ones. So I definitely think that the current composition of the court, incredible credentials, they all, with the exception of Justice Barrett, they all went to Harvard, Yale Law School. They were all kind of from birth groomed to be these kinds of highly credentialed technocratic justices, and we might be better off to have people with all kinds of life experiences.
Right. Yeah. I noticed on the bookshelf, Adam, behind you, Brandeis, who himself was with the Federal Trade Commission and whatnot before going to the bench.
Yeah, it was a real leader of the progressive legal movement, and it's been a long time, and it's a little hard to know whether such a person would have a shot at the Supreme Court these days.
Right. Well, I think it would be difficult given the way in which it has become this hyper-professionalized kind of court of appeals court. I mean, drawing from the kind of folks who are at the Court of Appeals. Yeah. All right. Well, this has been a wide-ranging and extraordinary conversation. I'm honored to be here with you to think through these issues that are so important, and I think we've put a lot on the table for our students to think about and struggle with over the months to come. So I really want to thank you all for being on this panel, Janai, Justin, Adam, and of course Eric, and I want to thank Beth Manchester for organizing this panel as well. Maybe we're coming to the end of the academic year. This is our final American Voter Project panel. Actually, we've past the end of the academic year here at Columbia. We're now in the summer term, but this is our last panel of the year. So I wanted to give you a chance to close us out for this year.
Okay. Well, first I want to thank our panelists. I actually learned a lot. This was I thought this was entertaining. I thought it was extremely informative. I hope our viewers found it as interesting as I did. And I would urge those who watch this to follow Janai's work, to read Adam Liptak, to follow the great work of Justice and see what he'll be doing on the commission. These are 3 scholars, 3 people who know that which we have been speaking about. And so I want to thank you all for spending time with us. I really do think that we are at a really consequential time for this nation and its judiciary, and more specifically for the Supreme Court. What the court is apparently poised to do, and I say apparently because there are always surprises, but apparently poised to do, could really reshape this nation in really kind of fundamental ways. And it'll be interesting to see what this new conservative majority does over the next couple of years and over the next couple of decades. But again, you never can tell. Things happen, and you don't know how long that majority will actually endure. But this is something that I think is worthy of our attention. Somebody was saying that liberals don't focus enough on the court, and I think that in fact that's true. We don't focus enough on our justice system and all the problems that it has. We don't focus enough on the Supreme Court, the selection of judges. But I think we're about to get a lesson that failure of focus and what it's going to mean for the way in which I think this conservative majority is going to change things in our society. I think it's going to really kind of galvanize people on the left, and I think in particular, I think the abortion case. I really do think that is one that is going to wake people up if it goes the way I suspect. I suspect that it is. But in any case, as I said, this is something that is that's worthy of our attention and that we should be focused on. I want to say a special thanks to Bernard for the work that he has done with the initiative over the course of these couple of years. He has been the person who has been the rock, the person who has organized, the person who's kept us focused. He has spent enormous amounts of time making sure that something that started out as only an idea has grown, and we still have more growing to do. But to the extent that this turns out to be something worthy and consequential, it's all as a result of your great work, my friend. And so I want to thank you for the time you spent, the relationship that you and I have developed. You are the molder of young minds, and you have expanded the area in which you do that molding, and it's all for the better, for not only for the legal profession, but for our country. So I thank you on so many levels, and thank you for helping us with the Holder Initiative.
Well, thank you so much, Eric, for anchoring this project, and for bringing all of your insights and really important perspectives into the mix. So it's been a real pleasure. Thank you, and a great friendship. I think that we'll call it a night now, and we'll turn it over to the Biden Review Commission to lead us forward, pros and cons of what we should be thinking about. All right, thank you so much, Janai Nelson, Justin Driver, Adam Liptak, Eric Holder. Thank you so much.
Thank you. It was a real honor.
Thank you. Have a great night.
Take care. Good night.